DCCR 0386. You're charged with the second-degree felony offense of intoxication manslaughter with a vehicle from December 11th of 2024. And how do you plead to that charge?
Guilty.
And y'all have marked here aggravated. What is?
Defense counsel put that here.
Yeah, they charged it as aggravated with a vehicle, I believe. It was aggravating.
It's just a garden variety intox.
Yeah, I'm going to mark that out because I think that might have some
Different context.
context at sentencing that you may not want. All right, so it's how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
Your size for a trial.
Sorry, give me just a second to get to the. And Mr. Broussard, this is cause number 24, DCCR 1150. And in that case, you're charged with aggravated assault causing serious bodily injury from April 20th of 2024. This was a final reset. The state was going to subpoena the complaining witness, Mr. Smith.
We did, we would call Lanielle Brianna Briggs.
Lanielle
Brianna.
Brianna Briggs.
Danielle, Brianna, no response, Your Honor.
Judge, we have sent a subpoena to Ms. Briggs for this case to be here. She's not appeared. She's not contacted our office. We sent it both certified and regular mail. We've not received anything back. So this time we will file dismissal against Mr. Broussard.
All right, I will sign that. Mr. Broussard, are you and Ms. Briggs still in a relationship? Okay. Obviously, whatever went on wasn't a good thing. The case is getting dismissed today. My suggestion is to stay away from her so that there's no other issues in the future, all right? You're free to go, sir. Mr. Each of those cases for early termination.
Judge, I know typically this is something that you reach out to us in advance and just get our input on it. I just wanted it to be on the record due to the nature of the offense. I've spoken with this probation officer, and I don't believe she has any issue with an early termination.
I don't-
Successfully completed Veterans Court and has done very well. I just was hesitant due to the nature of this offense.
So my issue with this, and I did get Ms. Malfino's response when I sent it to her. The judicial clemency part is my issue based on the nature of the offenses.
It's deferred or is it straight?
It's deferred.
It's deferred. So judicial clemency wouldn't be, did I write judicial
You
clemency?
did.
Oh, well, you don't need to grant judicial clemency because he doesn't have a conviction.
Right, that's what
And
I,
I think that was an issue I wanted.
yeah, I definitely did not.
I'm
I
sorry, so
definitely
that
do-
was just a holdover, I think, that I just didn't notice in our filing, so I apologize. So sometimes that comes up, but only with a conviction case, Judge, and these are
Right.
both deferreds. So judicial clemency shouldn't be an issue.
I did also, for the record, get a response from probation from Ms. Martinez that states that pretty much what Ms. Malfino stated, that he successfully completed the veterans program, completed anger management, that he has done well. They just, due to the nature of the offenses, aren't going to make that recommendation and would defer to the court, but are not opposed to it. And that's the position of the state as well.
It is.
Then at this time, I will grant the motion for early termination of community supervision in each of those cases. I am going to mark through some of this, well, I'm gonna mark through that request, that the request came to be considered and motion for, mark through that. So I just marked through the part that you talked about judicial clemency.
Okay, thank you,
And I
Judge.
have granted.
I apologize for that.
Nope, that's okay.
That's an oversight on my.
So, Mr. Rogers, it sounds like you've done great. You're what we want to see with everybody on probation. You've been on for a little over half of your probation period, so you're entitled to early termination if you've done certain things. This is the type of case where I'm glad to be able to say that you've done it all. And I'm signing the order today, so you will be off probation. All right? Good luck to you. Thank you. This is Ms. Malfino. Oh, she's right there. She's coming. It's all good. Good morning. You're Ryan Hodge. And Mr. Kimler, will your client waive the formal reading of the indictment?
So waived.
And we're going on the full indictment, correct?
Correct, Your Honor.
Mr. Hodge, in cause number 24, DCCR 1167, you're charged with third-degree felony offense of evading arrest or detention with the use of a vehicle from April 11th of 2024. Your indictment further alleges that you were previously convicted of burglary, a second-degree felony, May 12th of 2015 in Grady County, Oklahoma, and on that same date, also convicted of possession of a controlled substance in Grady County, Oklahoma. And then after those were final, you were convicted March 20th of 2018, also in Grady County, Oklahoma, of bribing an officer. And on that same date, convicted of a felon in possession of a firearm in Grady County. How do you plead to that charge? So how do you plead to the original charge that you're evading arrest or detention with the use of a vehicle? And are those prior convictions true? Did you enter your plea of guilty in true, freely, and voluntarily? And because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And so, is there a fine agreed to?
I marked a fine. I would look that up to the state.
500 is fine.
So it looks like the agreement that you've reached with the district attorney is for a 10-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? I want to make sure you understand that because you've entered a plea of true to all of those prior felony convictions, that this is a little different than a normal 10-year deferred. If you violate, your minimum punishment by law that I could give you if you violate this probation is 25 years, non-negotiable, because you've pled to it this way. If you violate, the minimum is 25. Do you understand?
Yes, ma'am.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Hodge is not competent?
None that I'm aware of, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your case, and then we'll come back later for sentencing. Do you have your discovery certification?
Yes.
Okay. Go
Can
ahead.
I inquire if he
Yeah.
has a GPS, Judge? I know he resides in Oakland.
Sentence her, it just turns into an issue if she doesn't.
Okay.
But motions for new trial and things like that, there's really not a lot of things we can do. So I can take the plea today. We can do the sentencing Friday. We can do the sentencing Monday during the next docket.
Okay.
I'm willing to do the week, whatever.
A couple of things, Judge. If we can maybe put on the record how we arrived at that time. And also there's the state, well, ordinarily I wouldn't be opposed to a defendant turning himself in at a later date. This plea was contemplated prior to today. In other words, this defendant knew that there was a very good chance that she would be going the other day. On its face, it just looks like a plain Jane state jail felony felony theft. But Judge, it appears that she may have been a part of a theft ring that committed more than about 29 total different crimes to the tune of about $50,000, Judge. So with all that being said, I'm not so amenable to her turning herself in later, but of course, it's up to the court.
So here's what we'll do. We'll go through with the plea, and then we'll be here and do sentencing this Friday at 9 a.m.
Yes, ma'am.
Can you do that?
I have municipal court in the morning, but
What time?
they typically start at 8:30. But I can,
I mean, it won't take long.
yeah, I can tell them I'll need to leave and come and go back.
I mean, we can do this at 8:30, and then you can just, instead of starting and stopping, and just be, I mean, it'll
Little
take
late,
10
yeah.
minutes.
Okay,
Would you rather that?
Yeah, that's
Instead of starting and stopping, just let them know you'll be a little bit late?
yes, that's fine.
Okay, so that's what we'll do then. All right, so, and you guys have talked to the clerk about the credit?
Yes, so there were several counties in which Ms. Wynn was transferred throughout from 2024 to 2025.
For various theft cases.
Okay.
Yes, from various steps in various counties. So we have, we know that Jefferson County put the hold on her in June of 2024,
Okay,
and then she was released in May of 2025
okay,
after completing all the other counties.
okay,
Yes, ma'am.
gotcha. All right, so is that your understanding of the agreement?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Wynn is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing to this Friday, which is January the 9th, thank you, at 8:30 a.m. It's very important that you're here on time because Ms. Holmes has something else she needs to do in another court. And so we'll all be here early. We'll get your case taken care of. You'll go into custody. If you don't show up this Friday, well, just let me go. Good, I hope so. But let me just, if you don't, then I don't have to accept this plea agreement and things could be worse. You understand? Also, if you're arrested for anything this week between now and when you come back Friday, you run the risk of me not accepting that agreement. You understand? And it sounds like there's the hold, there's some documentation of the hold that we had. And so the credit from that June date in 2024 to the release date in May will be granted as far as back time.
Yes.
Did we already admit one?
No, Judge.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Wynn is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, again, I'm going to reset your case until Friday at 8:30. We do not need a pre-sentence report. You'll come in and be ready to go that day with the bailiff, okay? All right, we'll see you Friday morning. And you've got your certification?